to the debate. I'm glad you all could make it. We will be debating DACA, as you all know. My name is Adam Wood. I'm the president of the Federalist Society here. I'm in my third year, so welcome. To my left are our two speakers. This is Josh Blackman. He is an associate professor of law at South Texas College of Law in Houston. He specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Skimming. Okay. He is an adjunct scholar at the Cato Institute and the founder of the Harlan Institute, and for fun, the founder of Fantasy SCOTUS, the internet's premier fantasy Supreme Court league.
You should all play.
Yes. You can check out his blogs at joshblackman.com. He is the author of over 4 dozen law review articles, and his commentary has appeared in the New York Times, Wall Street Journal, Washington Post, USA Today, the LA Times, and other national publications. To his left, theoretically needs no introduction, but...
I'm further to the left, that's for sure.
Yes. We have Professor Jones, who's an associate professor of law here at NIU. He teaches con law, civil procedure, evidence, conflict of laws, antitrust, and Supreme Court litigation. He joined NIU in 2007, and he received his JD from NYU and his bachelor's degree from UC Berkeley. He began his legal career as a judicial clerk for the Honorable Jack B. Weinstein in the Eastern District of New York, and he then practiced antitrust law in Washington, D.C. as an associate at the firm Arnold & Porter. He is a member of the California and D.C. bars. So, without further ado, Josh.
Thank you so much. You can clap. There it is. Thank you. Thank you so much. I think this is my third time at NIU, Robert, I think? Third or fourth, maybe?
Second with me, right?
Okay, so I think third total. I always like coming here. It's a nice place, quiet campus, and it's always very welcoming, so thank you. A little bit colder. I live in Houston. Had to bring a jacket, which I don't always like doing, but I have to remember to pack one. The topic today is DACA, and I want to put my cards on the table right away. I'm in a weird spot. I like DACA. I like the DREAM Act, and I think our immigration laws are far too restrictive. I believe this fervently. I really wish Congress would get its act together and take care of the Dreamers as well as their parents, and in various regards. And I say this emphatically and honestly. So far, so good, right? The next part, not so good. I have serious doubts about the legality of the deferred action policy. I also think that the president was justified legally in his decision to wind it down. So I wrote an amicus brief, a friend of the court brief to the Supreme Court that was a little bit weird. And we called the brief a brief supporting DACA as a matter of policy, but supporting the government as a matter of law. And this is one of those weird cases where my own preferences on politics don't line up with my views on the law, and this happens quite a bit as it comes out. One of the most famous cases I'm sure you're aware of is the flag burning case, right? Texas versus Johnson, which you probably studied. And that was a 5-4 decision, which held that flag burning is protected by the First Amendment. Who was in the majority for that case? Justice Scalia. Now, did Justice Scalia care for flag burners? No. He once said, I would lock up all the hippies, throw them in jail. He did not care for them. But he found his First Amendment principles were strong enough. And I'm sort of the spot in reverse, where I think the DACA policy is a good one, but not one supported by law. So I want to move in a couple parts. First, I'd like to walk through the background. Let me just hide this just for a minute.
Jerry, I can...
Yeah, I'll just unplug it. Okay. That's not mine, it says. So first I want to explain what is DACA, what is the history of this policy, and how did we get to this point. Then I want to discuss whether the policy itself is legal. And the final aspect is whether the decision to wind down the policy was justified. Okay. So what is DACA? DACA stands for Deferred Action for Childhood Arrivals, DACA. What is deferred action? Deferred action is not actually defined by statute. But deferred action basically means that the government says, we are going to deprioritize this person for removal, right? So if there's a long list of 1 million people for removal, you go to the end of the line. But there's other stuff that comes with it. Once you get deferred action, you get what's called lawful presence. And lawful presence gives you entitlement to a lot of benefits. You can work legally. You can get various federal benefits. In some states, you can get driver's licenses. There are a host of other things that come along with deferred action. So it's not just preventing removal. There actually are federal benefits that come along with it. In 2012, I'm sorry, in 2010, the president, I'm sorry, 2012, I'm sorry, the president announced a policy known as DACA. This policy would give deferred action to a specific group of people. That is, minors who came to this country through no fault of their own. They've lived in this country for a number of years. They've been educated, they did not get in trouble, they had no criminal record, and if they checked all these boxes, they would get this status known as DACA. DACA was viewed as a temporary bridge, right? And the thinking was, at some point, Congress would get its act together and pass the DREAM Act or similar legislation, and then these people would have a permanent form of status. Okay, that didn't happen. So now DACA has been this sort of temporary executive action that's been in the book for what, almost 7 years. It's been around for quite some time. In 2014, President Obama announced what would have been the second major deferred action policy, DAPA, D-A-P-A. So you have DACA and you have DAPA. DAPA stands for Deferred Action for Parents of Americans and Lawful Permanent Residents. It's really Doppler, but we'll just go with DAPA for now. DAPA would have given deferred action not to the children, but to the parents of U.S. citizens, as well as the parents of lawful permanent residents as green card holders, right? So if you came to this country, you had a child, your child's a citizen, you're not, you can now get deferred action by virtue of your child. Okay. DAPA was challenged in court by Texas. I filed some briefs in that case back in 2015 and 16. The district court halted DAPA and found that it was unlawful. The Court of Appeals affirmed and found that DAPA should not go into effect. The case was then appealed to the Supreme Court, and they granted review. However, after review was granted, Justice Scalia had passed away. As a result, what would have been, I think, a 5-4 decision in favor of Texas became a 4-4 decision. No decision at all. When the court splits 4-4, you simply affirm the lower court decision. So the upshot was DAPA did not go into effect, but there was no SCOTUS decision on point. Okay. I simply assumed that Hillary Clinton would win the election, and after the election, Merrick Garland would be on the Supreme Court, or maybe someone else, and they would uphold DAPA, and then we'd be over with this. Not quite. President Trump did win the election, and after he won the election, he announced he was not going to implement DAPA. So that was the end of the DAPA program. But initially, Trump left DACA in place. He left it in place for at least some period of time. Texas was not happy with that, and Texas sent the DOJ a letter and said, if you don't wind down DACA, we will sue you, using the exact same legal theory that we used to challenge DACA, the first policy. After a couple months, the DOJ said, okay, we're going to wind down DACA. And the Attorney General put out a letter explaining why he thought that the policy should be ended. Okay, so now what happened? Instead of red states suing to end DACA, blue states began to sue to preserve DACA. We had lawsuits from California, in New York, across the country. I think there were 4 or 5 or 6, I've lost track actually. There were a bunch of different suits challenging the decision to wind down DACA. And all the lower courts agreed that the president's decision to wind down DACA was not adequately justified. The Supreme Court granted review. And we'll hear arguments in this case, oh boy, about 2 weeks, in November, the second week in November. I'll actually be at the court for that one. That's a long story condensed in a condensed time frame. Okay, so what are the issues the court has to confront? Okay. One possible issue is DACA itself legal, right? If the court finds that DACA is not legal, then of course the president can wind it down. It's contrary to law. What if there's a different question, right? What if the court says that the president and the attorney general did not give a good enough reason to justify DACA? That is, the government said, we think this policy is unlawful. And the court says, no, you're wrong, it's legal. In that case, is the justification given arbitrary and capricious? If we take an administrative law, that's a phrase you know, basically means irrational, if you want to look at it that way, right? So the court's going to have to decide, I think at one level or another, is the DACA policy legal? Okay, so let me actually give my argument in chief, which I've been dancing around now for a few minutes. I think the DACA program cannot be supported by statute. And let me explain to you why. There is no express statute that says the president can, or sorry, the Homeland Security Secretary can give lawful presence to maybe up to 1 million aliens. That statute does not exist. Instead, the government's relying on fairly generic delegations of authority. For example, 6 U.S.C. 202 Section 5. Of course, everyone knows that one, right? Which gives the Secretary the power to, quote, establish national immigration enforcement policies and priorities. There's another provision, 8 U.S.C. 1103A. Of course, everyone knows that one, right? Which charges the Secretary to administer and enforce various laws. That's it, right? These are very generic statutes that give a very broad delegation of authority. And there's a principle of administrative law that says Congress does not quietly delegate authority to agencies of a high magnitude. That when Congress wants to give an agency a lot of power, they do so expressly. Justice Scalia explained it in a memorable fashion. He said that Congress does not hide elephants in mouse holes, right? That if there's this huge grant of authority, it won't be squeezed into a little grant. When I look at these two statutes that are used to see DACA, I see mouse holes, right? These are very generic delegations of authority without any specific instance or guidance that the president will be able to grant lawful presence to up to 1 million aliens, right? These statutes are not enough to support them. What if I'm wrong, right? What if, in fact, these statutes do give enough authority to the executive to enact a policy of DACA's magnitude? Then these statutes are problematic, right? There's a provision of law known as a non-delegation doctrine, which you may have learned about or not. And this is the idea that Congress cannot delegate to the executive the powers to make laws. We know from Schoolhouse Rocks that Congress makes the law, the president enforces them. What if the Congress put a statute saying the president can enforce whatever immigration law he wants? No discretion, right? Whatever immigration law president wants, you can do. Would that law be constitutional? I don't think so. I think that would have serious non-delegation concerns. If we read these simple statutes about setting priorities as giving the president this awesome authority to basically suspend the deportation of 1 million aliens and grant them lawful presence, then the INA itself may be unconstitutional, right? The immigration laws themselves may be unconstitutional. So to avoid reading the ACA, wrong debate, to avoid reading the INA as unconstitutional, I think courts should hesitate before giving the president this much authority, okay? But let's say I'm wrong, right? Let's say that you don't agree with me, and let's say you think that the statutes do give this much authority. Then we turn to the question of deference, which is something we always talk about, right? Deference. So for example, you have Chevron deference, the idea that if you have an ambiguous statute, the courts will defer to an agency's reasonable reading of the statute, right? Here we have a situation where the Attorney General has said, we've determined that this policy is unlawful, that to enforce this policy would violate the president's duty to take care the laws are faithfully executed. I humbly submit that's a judgment entitled to some deference, right? Even if you disagree with it, it's a reasonable judgment, and one which the court should be very hesitant to second guess. This is not just saying, you know, how do I interpret some obscure statute about chemicals, how many particles per million in an emission, right? I don't really care about that stuff, right? That let courts fight over that. But here the president's saying, I think this is unlawful. The AG said, I think this is unconstitutional. That would violate my duty of faithful execution. If you have the AG making this sort of statement on the record, I think there's a very strong presumption of regularity that you adhere to this, right? You say, we don't have to decide if DACA is legal, we'll just adhere to it. Now, what's the advantage to that approach? If the court agrees with me and says DACA is illegal, that means that President Elizabeth Warren, in a year and a half, can't reinstitute DACA, right? There's an advantage to the narrow approach I'm giving you, right? Which is saying, we won't decide it, but we'll say Trump can wind it down. Let me tell you something. If we get a decision in June of 2020, it ain't going anywhere before the election, right? It'll be phased out in an election to bridge the gap. Just practically speaking, it's not going to happen. So maybe the best answer is you get back to the political process. Now, I think my first argument is correct, that it's illegal. But I think the court's unlikely to resolve legality and just say it's reasonable, we'll defer for now, maybe let Elizabeth Warren, whoever else, put the policy into place on a more stronger footing later on. Of course, what's going to happen? Texas will just sue her again, and we'll be back to where we started from. Back we started from 2014. Nothing ever ends. But I think that's probably a more desirable route. But if the court does go down my road, which I think they might, then you have a very strong ruling about delegation of power, and the idea that the executive branch has to read delegations as they're written and not assume too much power. This is an argument that, in theory, everyone should agree with. President Trump has relied on statutes in a very broad way. The travel ban, the emergency declaration, you name it, right? You take these sort of mundane statutes that don't address a problem, and you read them to give a big font of authority. My position, right or left, red or blue, is we read delegations narrowly. It will hamstring Barack Obama. It will hamstring Donald Trump. It will hamstring Elizabeth Warren, as it should be, right? We should not let the executive run amok, even if you like the policy. Now, I'll address the point. I'm going to wrap up and turn over in a minute. This is real world implications, and there are people here who are on DACA who will be directly affected by this, and I sincerely feel for them. They've been used as a bit of a pawn in this sort of entire game, and I think it's quite unfortunate. I hope Congress does get its act together. If there's a court ruling saying this is illegal, I think you'll see the legislature move pretty quickly, maybe not before the election, but maybe after the election. We'll see. All right, I think I'm done for now. I'll turn it over to Professor Jones, and I welcome your questions. Thank you all so much.
Thank you. I want to thank Professor Blackman for coming in to talk with us. Right? I mean, it's regardless of who you agree with more, or what side you end up taking on issues like this. We all benefit from the discussion. We all benefit from talking to each other about it. It's what law school is supposed to be all about, the free exchange of ideas. We're all better for it, and it's happened because he was willing to take the time to come here and share his expertise with us. And you wouldn't want to hear me talking to myself. I mean, that would be near as exciting. And I want to thank Adam. He's a great student of ours for putting this together, and for the Federalist Society for putting this together. Let me put my slides in here. I just want to take, to a certain extent, an opportunity to discuss DACA a little bit, because I don't know how much you know about DACA. I think it's a really important issue, and it's something that's important to me as a Mexican American. I've had students who are DACA recipients. We all know people who are DACA recipients. Whether you know them or not, they're in your lives. Sometimes they don't want to reveal it, but it's something that we all should be.
Oh, I'm sorry I screwed up your thing.
No, it's all good. It's all good. I can just remember my password.
There you go.
So let me talk about DACA just for a second in general, and then get to the issues that Professor Blackman has teed up. So DACA stands for Deferred Action Against Childhood Arrivals, right? It's adopted in 2012. Let me get the slideshow going. Okay, and it was, the title of the memo that started it was Exercising Prosecutorial Discretion with respect to individuals who came to the United States as children. It grants recipients basically 2-year periods of reprieve from deportation, and also oftentimes accompanying that are 2-year periods of work authorization and the right to driver's licenses, for example. And then they tried to expand it to 3 years, but that was part of the DACA expansions that Professor Blackman was talking about that had trouble in the Fifth Circuit. In order to qualify for DACA, you had to be younger than 31 on the date of its enactment. Younger than 31. You had to have arrived in the United States when you were younger than 16, and there's many people in that boat. In fact, 80% of DACA recipients came here when they're younger than 10. You must have lived in the United States since 2007. You had to be a student or be a high school graduate or be in the military or honorably discharged from the military. And then you cannot have a serious criminal history or you cannot be otherwise posing a threat to the national security or public safety. So they, when you apply to DACA, they can analyze it, they work on that case and try to determine whether they think you're a threat in some sense to national security. So as of June 2019, we got about 660,000 people who have received DACA. All right, so close to 1 million people in the United States right now are DACA recipients as we speak. You know, Illinois is 4th on the list in states in terms of how many DACA recipients we have. About 80,000 people in the state are DACA recipients right now. California is the most with 424,000, and then Texas, then New York, and Florida, Arizona right behind us. So we're talking about a very large group of people who are really interwoven in the fabric of our society in all sorts of ways that I can talk about in a second. But when Trump tried to wind it down, so to speak, and terminate it, he was challenged, as Professor Blackman was saying, and there are 3 cases, more or less, that have held that it was for ending it or arbitrary and capricious. So I don't think anyone is actually disagreeing that Trump has the right as the president to stop the program. If he wanted to. If he wanted to say, I don't believe in this anymore, that's his prerogative as president. What the courts have a problem with is they feel he's being dishonest and disingenuous by trying to say he's doing it because it's unconstitutional, and that actually does not appear to be the case. And what the courts are reacting against is this disconnect between his right to terminate it if he wants as a policy matter and the reasons he's actually purporting to end it for. And that disingenuousness is what's bothering them to the extent that they think it's actually arbitrary and capricious for him to say he's doing it because it's unconstitutional, when that does not appear to be true, in my opinion, and in the court's opinion. So let's look at so the court in the Eastern New York, which is one of the cases, said, look, the decision to end the DACA program appears from their statements to rest that they are saying it appears to be exclusively an illegal conclusion that the program was unconstitutional. And the reason why Trump is trying to justify ending it on constitutional grounds is because he doesn't want to take the heat for actually saying he disagrees with it. He doesn't want to take the heat for ending it. He wants to basically have his cake and eat it too, and saying, well, actually, I have no problem with this. This actually seems fine to me. But there's nothing I can do because it's unconstitutional. And of course, that's just his law to American people. And you can't do away with that kind of law. Step up to the plate and just admit that this is something you're against, and we'll approve it because that's your prerogative as president. But don't hide behind a constitutionality argument that we don't buy. So this is the reason why he is not willing to admit he's against the program. It's because the vast majority of Americans are in favor of the program. Even Professor Blackman, and I respect the distinction between thinking something is a good policy reason, but just having qualms about it constitutionally. I get that and I respect that. In terms of DACA recipients, most recipients were, the average age of becoming lawyer was 7. If you're looking at DACA recipients, 59,000 homes in the country are owned by DACA recipients. They pay $613 million every year in mortgage payments, $2.3 billion in rent each year. They're parents of approximately 256,000 children born here, and therefore you're talking about 256,000 American citizens who would lose their parents if they were born. You're talking about a $2.3 billion loss of rent payments. I mean, I could go on and on. We've got most of these DACA recipients are working. Many are in school, but 66,000 are working in the food prep industry, 66,000 working in offices, 61,000 are in sales, 28,000 in business, 27,000 are healthcare. Some of these DACA recipients are doctors and nurses now because they've been here long enough. 16,000 in education. If you aggregate all, according to some studies, their taxes, because once they became DACA recipients and could work legally, now they have to pay taxes. Whereas before, when in the shadows, working on the table, by definition, they couldn't be paying taxes. But we're talking about $5.7 billion every year in federal taxes that DACA recipients are paying, and $3.1 billion every year in state and local taxes. So you can't just take these people out of society all of a sudden and say, well, actually now we changed our mind, you should now be deported. It would create, just not even looking at the injustice of it and the unfairness of it, just the dislocating effects on the American economy alone, I think is part of why there's widespread opposition to the termination of DACA from Republicans and independents as well as Democrats. Just as a practical matter. These are just three examples of DACA recipients. Vera Cruz came to the country, she was age 7, earned her college degree, and then I was a teacher in the 3rd grade in Oregon. Sana came from Saudi Arabia at 14. She's a tech innovation designer in New York. She's paying for her siblings' education. And this gentleman is one of my former students. He graduated from NIU in 2015 and passed the bar. He's the director now of legal services for the Illinois Business. He's the legal director for the Illinois Business Immigration Coalition. He came from Mexico with his family. He was 2. He didn't know he was undocumented until he went and tried to get a driver's license at 16. He went and took his driver's license and they said, you can't have one. And that's when he went home and had a discussion with his parents who said, you're not here legally in this country. So he was able to come to NIU because of DACA, and he was able to take the bar because of DACA. And now he's marrying a U.S. citizen now. So, I mean, look, you may, there's about 1,000, almost 1,000 DACA recipients who are currently in the military. They were chosen to be in the military because they have special skills like languages. These aren't DACA recipients per se, but about 3,000 veterans have been deported. I don't know if you know this, but that gentleman, for example, Hector Rajas, came to the country at age 7, grew up in California, and at 17 joined the military. But then after the military, he did commit a crime. Should have gone. He went to jail like he should have, but then he was deported. So similarly with Jose Benitez, served in the military in Iraq, came back with a brain injury and post-traumatic stress disorder. Had a drug problem after he came back and engaged in some violent activity. Went to jail as he should have, but then when he got out of jail, he was sent to El Salvador, and just released on the street. And he hasn't been in El Salvador since he was 3. So you're talking about John McCain spoke out against the termination of DACA, and a recent CNN poll said that 83% of Americans favored continuing DACA, and 94% of Democrats, 83% of independents, and 67% of Republicans. So this is why Trump doesn't want to just end up and just say, I ran an anti-immigrant platform, this is what my base wants, I'm just going to do it. He would lose too much from a political point of view. So that's why the courts are upset, is because he's purporting to terminate on the grounds it's unconstitutional, and that's the only grounds on which he's purporting to end it. And the courts feel that that's just a lie, and it's arbitrary capricious as far as it's not the real reasons or even a valid reason. So real quick, in terms of my argument that DACA is constitutional, and this is something where Mr. Blackman and I can kind of engage more directly because he agrees with me, right, that it'd be crazy to end DACA for all sorts of reasons in terms of justice and fairness, but also in terms of just in terms of the effects of American society, just pull that many people out of American society who are just embedded in it. But in terms of its constitutionality, Mr. Blackman and I just really disagree on how this should work. I mean, I'm a firm believer in prosecutorial discretion. I think that and many other people agree with me, that our constitutional system was designed for prosecutorial discretion. We have separation of powers because the people who wrote the Constitution felt that Congress needed to be dependent on the executive for the enforcement of the law. It's unconstitutional as a matter of separation of powers if Congress can actually enforce their own laws, because the feeling was we're more free and our liberties are more safe if the executive gets the final say on which laws are enforced and how they're enforced. Because Congress sometimes makes mistakes. Congress sometimes can pass laws that are very unfair and unjust. And the executive can step in and say, I'm not going to enforce it that way. I'm not going to enforce it at all. Or if a law looks good on paper but ends up having unfair applications that Congress didn't anticipate, the executive can mitigate that and say, look, I'm not going to enforce that law in that way, or in this instance, or to these people. That's a check. That's a crucial way in which congressional mistakes can be compensated for, correct? having the prosecutor, having the executive in a position where they can come and say, I'm not enforcing it that way, or at all. We see that on the local level all the time. And the prosecutors say, I'm not charging him. I'm not charging him at all. And this is survivor of domestic violence. I'm not going to send her to jail for the rest of her life because she defended herself. Or I'm going to plead it down so that she only gets 5 years. We say that every day with prosecutors, where they get to sort of make sure that justice is done by not just kind of blindly across the board applying the laws to the full hilt all the time. Our system wasn't designed to work that way. The feeling was that we're more safe and the society's more fair and everything is, our freedoms were protected if the executive in essence has to check on what Congress can do by not enforcing things. So look, you can't enforce all the immigration laws. We have 11 million people who are undocumented in the United States right now. You can't just deport 11 million people. You wouldn't even have the money to do so. You can only deport, just in terms of the resources they currently have, 3% of those people can only be deported each year. So you have to make choices about who is or isn't going to be deported. And I just don't see how you can argue really very successfully that it's unconstitutional for the executive to say, I'm making choices here. I can't deport everyone. Congress hasn't given me the money to deport everyone. So I'm going to choose to deport these people and not deport people who came to this country that are 3 or not working and have no criminal history. How can it be unconstitutional to make that choice as a policy matter when you're enforcing the law and making intelligent decisions about how to go about enforcing it? We've had these deferred action programs in all sorts of contexts in the past. We have a history of them. And so I think it's just the way our system is designed to work. And so I just disagree that this is a policy-making endeavor. I think it's a situation where Congress has set the policy and the executive is now deciding how to enforce it. And they're just making choices about how to enforce it. I do agree that the distinction could be made, although I don't think at the end of the day that there is a distinction, but I understand the argument that Professor Blackman was raising about how the work authorizations are a little bit harder to defend because there you could argue that that's a situation where the president's not simply refusing to enforce something, but they're actually giving something. So I see the argument's a little bit stronger there, and it's possible the Supreme Court will draw a distinction there and say, you can't argue with the president's decision not to enforce something. That's unconstitutional. If Trump wants to stop that, he needs to step to the plate and just admit it. But I can see them trying to argue that the work authorizations are on a different footing. I don't think they are, I don't agree, but I can see that a distinction, and they could sever DACA and say the work things have to stop, but the deportations are totally up to the president, and he can't simply say it's unconstitutional and decide who to deport. But I disagree in part because of the statute, and Professor Blackman and I can disagree about, about this, but I think this is enough of a congressional authorization. 1324A(H)(3), Congress said that the Attorney General gets to decide who is or isn't authorized to work in terms of how to define illegal aliens, terminology in the statute. So I personally think that is enough of a statutory hook by Congress to actually authorize the work permits as well. So there we go.
Thank you so much. It's a model of clarity that two people in district can have a civil conversation. This is not like Twitter. This is an actual, don't look to Twitter, don't look to cable news as a model. I'll make a few points in response.
Did I not call you enough names?
You jerk. No. And let me hijack his slide for a minute. I'll start here, right? And we'll talk about delegations of authority. Texas and the other plaintiffs never challenged the forbearance of removal, that is, the decision not to deport. The only thing that was challenged was the granting of lawful presence. If all DACA did was give someone a do not deport card, not a report card, a do not deport card, I would have a very different position. I think that may pass muster, right? If it's merely exercising forbearance, I think it goes too far. The difficulty arises with work authorization because there are lots of statutes that who gets to work in the United States and who doesn't. People wait years for green cards. People wait years for work authorization. DACA sort of sidestep all of that. So regard to some tension. Now, this statute certainly says authorized by the Attorney General. How many people are actually authorized? If you go back and look at the legislative history of the regulations implementing the statute, the government said that there's so few people who will get authorization, it's not even worth keeping records, right? This is a provision that was not designed for 600,000, a million, whatever it is. It was designed for a couple people on an ad hoc basis. So this statute cannot fit DACA. This is a mouse hole that cannot fit the elephant. Let me hijack one more of your slides. Without question, right, the government does not have the power to deport everyone. I get that, right? But that doesn't necessarily get you to the work authorization. Last point, I don't think you even mentioned these, Professor, but there were previous instances in which presidents have used deferred action. It says there since the 60s, but these were primarily since the 1990s. Why 1996? Because Congress repealed a statute in 1996 that authorized past deferred action. So all these ones from the 60s, 70s are not relevant. We're in the 90s now. I'm going to use the Katrina one as an example. So here's a hypothetical, right? You are a foreign student. You're on a student visa. You're studying at Tulane University in New Orleans. Katrina slams the Gulf Coast. Your college now shuts down. You are now no longer in school. You don't have the credits. And because you don't have the credits, you lose your visa. President Bush said, here's the deal. If you enroll in another university by January, by the following spring, I will bridge you. I will give you deferred action for a few months to bridge the gap. You had status, you lost it, but there's status waiting for the other side of the rainbow, right? That is how deferred action operated, as a bridge where someone has status waiting from the other end. DACA does not fit that bill. The Dreamers do not get status unless there's some other basis. For example, they marry a U.S. citizen. That might be one basis, right? But they don't have any sort of statutory obligation on their own to get status. And that's why deferred action doesn't fit past practice. It's not supported by past practice. I don't think the statute can read this broadly. But even if we disagree, I think these arguments are reasonable enough to uphold the decision to wind it down. Okay, thank you so much. We have some time for Q&A. Thank you. Thank you. Okay. You can do it. You know the crowd.
We have like a soft end time right now of like 5 o'clock, but would it be okay with everyone if we went a little bit over?
I can't.
Questions?
I can't. I gotta do 5.
Okay. Never mind.
I have a flight to catch, unfortunately, at O'Hare, and getting there is not easy, so I'll have to leave at 5. I appreciate the 5 it is. Thank you. Okay, yeah, in the back.
Yeah, so this is partly just because I've not been paying as much attention to the national debate as I have to this debate. So forgive me if my question is just repeating here. I guess my initial question is, on what authority are the courts resting that they have the power to state that the removal of DACA is capricious and arbitrary? Why does the judicial branch have authority to tell the executive how to operate in that capacity?
Okay, I'll handle that one. So there are 2 issues there, right? DACA was announced by memorandum. Professor Jones mentioned the title a few minutes ago. It was not put through what's called notice and comment rulemaking. And the Obama administration said you don't need notice and comment because it's just an announcement of priorities. If President Obama was right that you don't need notice and comment to create it, I think that the flip side's true also. You don't need notice and comment to rescind it. But the courts have said that this was actually administrative action subject to the APA. Right? In other words, if the rescission is subject to the APA, then the creation was also subject to the APA. But if the creation was not subject to the APA, then the rescission isn't. That's another way the court can duck the issue, say this is just not subject to review, and the court can take that road also.
Does that answer your question, Dan? I mean, you're wondering why the Eastern New York and the California court are saying that Trump can't do it?
Yeah.
Well, they're saying it's arbitrary and capricious because the reasons they are stating are A, not their real reasons, and B, just not. There's just not a strong enough argument that it's unconstitutional for you to use that as your only basis. So,
I guess my question is, if this is an executive action, why does it matter what the rationale for it is?
well, executive action still have to pass the APA,
Yes.
most of them.
Yeah.
And so the APA has a very, very slow minimum threshold. The executive can do pretty much anything it wants as long as it's not arbitrary capricious, which is a very, very low standard, which is why it's a little surprising the courts pull back so much. But they just feel this is so transparently disingenuous that they're actually taking this somewhat extraordinary step of saying, you've got no reason for doing this. That's the standard pretty much, is you don't have any reason for doing this. And they're pulling that trigger because they feel that that there's really very, very a slender read. No court has ever held DACA unconstitutional, right? And no court's ever held DACA as unconstitutional. They did say that DACA violated the APA. One court did, and then the Supreme Court went 4-4. But no court's ever said DACA itself is unconstitutional. for Trump to say, oh, I'm so sorry, I just have no choice, when no court has ever said it's unconstitutional, they're saying it's arbitrary.
Yes.
So everybody in the room is conceding then that we only have the resources to remove 400,000 a year? Okay. So for the remaining people that are here, did we say the average age is 7?
They entered when they were 7, I think.
The DACA recipients were
Now they have to be older at this point.
Okay, 'cause I was going to say, that if they've reached the age of majority while they're here, and you're saying your issue is with the fact that they're being given work authorization, how do you propose that they contribute to society?
That's a lovely policy question, and I agree entirely, which is why a statute should be passed.
That's one that doesn't disappear until the statute is passed, and we've had a significant amount of
I
time
do.
we can't pass the statute. So can I ask the rest, and then I would be very happy to hear your answer. So as far as also receiving medical benefits or driver's licenses, so basically you're advocating toward them having a position where they're forced under duress into entering into agreements that are all fraudulent because they have to conceal their status if they don't have a social security number or work
Mhm.
permit. How do you propose that the people who are living here that ostensibly we are not supporting, and you say you support them lawfully staying here, how do you suppose that they contribute to society or take care of their families?
That's a fair question. My advocacy is not about the policy issues. If you want me to say what I'm advocating for, is you pass a statute tomorrow to give them citizenship, so they don't have to deal with this temporary stuff. That would be my advocacy. But here's what happens when you take an executive action that takes 7 years to resolve, right? People get reliant upon DACA. Right? This is supposed to be a temporary policy, maybe for a couple of years, but now it's been for 7 years. And when you have this action for 7 years in effect, at some point, reliance interests kick in, and I think Congress has to intervene. But that doesn't create a statute. That doesn't create the authorization. I know that's very hollow words, someone who might lose their job or deportation. Very often the law leads to very unfair consequences, which is why when the law is unfair, it should be changed, not through judicial or executive rewriting. But thank you for the question.
Yeah, just real quick point. I mean, I agree with a lot of what Mr. Blackman said. I mean, just side note. I mean, my recollection, I'm not an immigration attorney, but my recollection is that we had a law that would have done these things. That was what I'm talking about. It passed the House and it passed the majority Senate, but a Republican filibustered, and we couldn't get the 60 votes. It's extraordinarily hard to pass legislation along these lines because it's controversial. And even something like this, where the majority of Americans are in favor, they still cannot come up with anything. So I'm not disagreeing with Mr. Blackman's point. I'm just pointing out that our system's not really built for expeditious legislative action.
Okay. Questions on this side of the room? Questions on that side of the room? No questions on this side of the room.
I'll walk over there if you want.
I'll call on you again if no one else. All right. Do I have another question?
Yeah.
Please.
So in the 1960s, there were other programs, and there have been ostensibly up until the 1990s. So how did we deal with this problem in the past? And then why is why is DACA that was instituted in 2012 so different fundamentally from these programs? Did you have a problem with these programs as well?
Oh, I gave the Katrina example a minute ago.
Sure, but that was in the 60s.
And the one in the 60s was based on a statute that's been repealed. In 1996, Congress enacted very extensive form of legislation. It was called not deferred action, but extended voluntary departure, which gave the Attorney General discretion to basically defer deportation, basically let someone leave and then come back, et cetera. That statute doesn't exist. So the only programs we have are those that Professor Jones listed on the board, and I can go through each one of them if you want. With the spouses and children of LPRs, people with VAWA, which is the Violence Against Women Act, widows and widowers of certain people in the military. These were all people who had status waived from the end of the rainbow, right? If they did something, they would get status. So for example, some visas are limited, say 100,000 visas per year. You apply in December, they're already out for the year. In January, you'll get it, right? Does it make sense to deport someone in December if they're going to have status in January? No, I think deferred action is a reasonable way to have a short-term game here. DACA was never designed to be a short-term bridge. It was meant to be sort of this ongoing process. Now existed for 7 years. And I don't think it can be squared with past executive practice. There's a file brief to the effect. Yes, sir.
Why should these people, why should DACA and DACA recipients bear the, how do you say, laziness of Congress, courts, and administrations? Why, you mentioned the rainbow example of Tulane and all those other colleges down there, Katrina. What about these people that are joining the American military and then are getting deported to El Salvador and Mexico? I mean, like, what are these people that are, delivering babies and nursing them back to health? And just anything. It could even be janitors. It could be anybody in this society that's not, all the hundreds of thousands of DACA recipients. How do you explain that, from your perspective, that the Tulane students in the limited circumstance of Katrina, even though yes, it's a hurricane, it's a couple months through or whatever, how can that not be extended to 7 years or more when we have purposeful gridlock in national and some state governments and court systems?
It's a fair question. I think it's unfair. Charles Dickens had a famous expression in one of his books where he said the law is an ass. In this case, the law is an ass. I firmly believe that. Sometimes the law is not fair. And I know this is hollow words. I've had DACA students, and they're not always happy when I say this, but I try to be as candid as I can be with them. My job here is not as an immigration expert, but someone talk about administrative law, which is usually pretty mundane. Deferred action was not designed as we need to fix the problems, right? It was designed in a limited context where someone had status, student visa, hurricane happened, they lost it, they got it back 2 months later. That was the idea, this temporary bridge, not a systematic program for hundreds of thousands of people to apply and stay on indefinitely. Congress should deal with this. I don't have a better answer than that, but I know that's not very reassuring.
There's some anger in the district court opinions because the majority of Americans are making the same point you are, Hunter. This is something that the majority, even Republicans, feel should continue for all sorts of reasons. And the district courts are angry because Trump wants to end it, but he doesn't want to admit that he's ending it. He wants to end it, but he doesn't want to take the heat by being honest and saying, my base wants to end this. So the district courts are insisting that if he needs to let it continue because it's the right thing, or he needs to just admit that he wants to end it as a policy matter. They're just not letting him off the hook and allowing him to say it's unconstitutional and that he has no choice. Because of the frustration so many people have about its continuance.
Okay, number one to number two.
I guess my question, you mentioned that DACA was intended as a temporary bridge. Was that intended as a temporary bridge until some kind of legislation
Exactly.
was passed?
Yeah.
So shouldn't that bridge remain until legislation?
Oh, I'd love that to be the case, but that's not how deferred actions worked in the past. If we say we keep this in place, the law changes, that means it's indefinite, right? There's no date certain on which a law will be passed, right? I think President Obama, if you asked him in 2012, said, okay, when the Congress turns over in a couple years, we'll get this done. That's probably what he would tell you, right? That didn't happen. In fact, in 2014, we had remember the Gang of Eight bill? Remember this one, right? This comprehensive reform, and the Republicans in the House never brought up for a vote, which I think was an unfortunate move. Yes, over there. Yeah. But then.
Is it me or is it you?
Right.
Oh, okay.
Yeah, right there. Yeah.
Hi. Okay. So this is maybe a bit philosophical
Uh-oh.
and sociological, but I'm just gonna put it out there for either of you to answer. But we keep talking about the law in a bit of a vacuum, I believe, and I think
Yeah.
that I understand this is a legal debate, so I get that. We're here in law school.
Yeah.
But if there's a law that's put in place that creates this bridge that gives access to work permits, just because a law is in place doesn't mean someone's going to get access to work, right? We all know that there are laws in place and things just don't work out that way for a variety of reasons. We're talking, race, gender, all the different things at play. And so I'm a bit curious to hear you speak to other factors, because to put all of your eggs in the law basket, and you keep saying that the law can be unjust and the law can be unfair. However, let's do the law thing. But the law thing doesn't always work out. So I'm curious to hear you talk a bit more. Perhaps it's more policy, but I'm just interested in your opinion on it. And I keep thinking about how whiteness plays into all of this, and that kind of an analysis, because I think by just speaking about the law, I think we're kind of, what's the word I'm looking for? I think we're not really giving people a fair shot by just saying that the law will fix this.
Thank you for the question. I don't know that I'm qualified to reply, and that's going to be something of a dodge. I'm a law professor, right? I'm not here as a philosopher, not here as a philosopher king. Certainly our judges are not philosopher kings. If those are interested in philosophy and policy, you go to the Congress, not the courts. So I know that's not what you're looking for, but that's the best answer I can give. But I do appreciate that you get to express your opinion on that. Thank you for adding to our discussion.
Yeah, just real quick, I just disagree that a bridge has to go down. I think bridges can stay up as long as they're necessary. And in terms of the, I think we have agencies because Congress is dysfunctional. 1930s, when the country's went through the Depression, we created agencies to get things done because Congress wasn't getting things done. So, that's why we have agencies. And so some people are just, I guess, a little more comfortable with giving them latitude to get things done when things need to be done. And people have different tolerance for how neatly all the I's have to be dotted. And I like agencies. I think they can accomplish things, and I'm willing to give them more latitude.
I think there's a hand somewhere over here in the back I saw. Okay, well, I have time for maybe one more question. I'll see if anyone else has any other non-repeaters. I like the people who are repeating. Okay, right there, yes.
At what point would you address when we're just making laws for the purposes of principle versus the purposes that it's something is injurious to the rest of society, and there is this ubiquitous issue that's just going to metastasize and hurt everyone else? What is the argument that this is a problem? Like, where is that coming from amongst the people that disagree with it, in your opinion?
Oh, the last part you threw me for a curveball. Just repeat the last part of your question. I thought I knew where you were going, then you curved.
What is the argument that this is injurious to the rest of society, that is not
That-
qualified as DACA?
So among people who favor more restrictive immigration policies, why? Okay, well, okay, now I got your question. Thank you.
Sorry.
That's okay. No, it's a good question. Okay, so it's not a position I hold, but I'll try to articulate the answer to her question. Some of it comes from a general opposition to immigration in general, which I think exists in certain segments. I think some of it comes from an idea of unfair competition, that there's a need to compete with immigrants for jobs. Perhaps some of it comes from the idea that the DACA recipients are skipping the line, that there are lots of people who wait in line for work authorizations. They can wait years and years and years, whereas the Dreamers got it automatically. I don't know if that fully answers your question, but that those are some of the justifications for why people may oppose this. I personally don't have a problem with it. I think it's a good idea if done through the right channels.
Do you think it would be fair to say that a lot of the arguments are based on principle?
Oh man, these are really good questions.
You hit me with that philosophical.
Yeah, I know. I feel like I'm out of my depth because let me answer your question this way, and I mean this sincerely. I think it's hard to know why people do what they do. We are complicated individuals. We all reach our position in life based on our experiences, where we come from, where our family comes from, what we learned, what we didn't learn. We all come to different places, and I am very cautious about ascribing judgment to people why they believe what they believe, or this principle or not. I don't know. All I can say is what I think, and then that's what I'm here for. But really good question.
I think racism exists, and I think it'll never go down unless we first acknowledge it. That's the first step, and then 12-step program.
Okay.
I'm not saying you. I'm not saying you. She just asked me about the 12%.
Oh, I didn't take it that way. Look, I've been called much worse, so it's okay. I've been protested. I've been shouted down. So this is actually very respectful.
You're asking why some people are so adamantly opposed to DACA. I think some subset of that is just irrational hatred, and that's something we should acknowledge.
And I think we'll have to call it here. If you have questions come up, I'd be happy to answer it. Thank you. You've been a wonderful audience, and I got to think about your questions on the flight home. So thank you so much. Thank you.